thank you again for attending the 2022 Elder Justice Conference. I hope you all were able to get some refreshments and gear back up after this morning's session, because this one's going to be an exciting one as well. Today in this session, we're talking about home ownership, reverse mortgages, and foreclosures. Before I go into a description of the subject matter and introduce our speakers, I want to go over some logistics. First and foremost, this is being recorded. You will get a copy of this. I think Kathy had said in about a week or so, it'll be uploaded to the virtual platform. There is another session going on at the same time that is also going to be recorded, so don't feel the need to bounce back and forth. You will have all the materials to all of the sessions that are ongoing. Second, I wanted to say and remind folks that we do have a live captioner here with us today. So if you do need to see the captions along with the presentation on the virtual platform, just click the blue box that says show captions and those should pop up. If anyone has any issues, just let me know and I'll do my best to help you out. Finally, for general announcements, questions and answers. Please, please, please put your questions and put your comments. We want to be engaging, and I know our speakers want to answer anything that you have on your mind. Preferably, if you could put those questions in the Q&A, that would be appreciated. That way we can organize them and be thoughtful in those responses. I know that our speakers have graciously agreed to try to answer whatever questions come in as they come in. So dig in when you hear something that makes you think about asking a question, feel free to drop it in the Q&A. And I think that's it for the boring announcements. So thank you for coming to Home Ownership, Reverse Mortgages, and Foreclosures. This presentation will be about the state of foreclosure risk, federal loss mitigation options, reverse mortgages, and the Florida Homeowners Assistance Fund program. The speakers that we have here today are Elise Cohen, staff attorney at the National Consumer Law Center, and Lynn Drysdale, attorney at Jacksonville Area Legal Aid. Now, without further ado, I will turn it over to our speakers. Thank you both so much for being here and dedicating your time to teach us.
Thanks very much. So I'm Elise Cohen from the National Consumer Law Center. I'm so pleased to be here today, and I'm going to kick our session off. We're going to start by talking about the players and who's involved in touching the mortgages that we're talking about today. So most mortgages, although not all, are securitized, meaning they're sold in groups, in packages to Wall Street. Sometimes that's done as part of government program, and it's done to Ginnie Mae, for example, or it's done, for Fannie and Freddie to Wall Street, or their private loans. So when you have these different players and these different structures, the question is, who controls the decisions that are made about the loan? Who can decide if the loan terms can change, if there's litigation? Who can choose to litigate? Who can settle? Who has the documents that you need? And sometimes it's the owner of the loan. Sometimes the servicer has that authority. The attorney plays an important role. So the focus really today is going to be on the servicer that the homeowner is interacting with, and what rules they're going to implement and how they interact with the homeowner. So now we're going to talk about the servicer and who servicers are. So a servicer is not the same as the owner or the investor of the loan. So when the loan is sold, or if the loan isn't sold and it stays with whoever first made the loan, there's a different party usually. Sometimes it's the same party as the owner, who's the servicer. And they're the party that's accepting the payments and passing on those payments if there is a trust or a different owner to that party. So there's a contract between the owner or the investor and the servicer. It's often called the pooling and servicing agreement in a private loan. If it's a government loan, then the government investor will have their own set of rules that are similar. And the thing about the servicer is they're working for somebody else, but they're the party the homeowner is obviously dealing with. And sometimes the servicer makes more money by not giving the homeowner the best possible service. So what determines what the investor's rules are? Now we're going to go to the next slide. So in a minute, we'll see a link that will give you more information on how to find out what kind of loan a homeowner may have. but this slide is about why it matters. So for example, if you have a Fannie or a Freddie loan, which is called a government-sponsored enterprise loan, a GSE loan, there'll be one set of rules. If it's a federally backed or insured mortgage from FHA, VA, or USDA, the three alphabet soup agencies that insure government mortgages, then they all have their own rules. And if it's none of those, then it's a private loan, which might have been sold on the secondary market or maybe held in portfolio by the original lender. If, as I mentioned before, the loan has been sold to Wall Street, the rules will generally be governed by the pooling and servicing agreement or the PSA. So what kind of loan modification guidelines are we going to see? We're on the next slide now. So the key first is to figure out what kind of loan you have. And at the bottom of this slide, I want to commend to you this chart from NCLC that we put together. It includes information about the investor guidelines themselves, but it also includes information on how to find out what kind of loan your client has. In particular, it may not be transparent whether your client has a Fannie Mae or a Freddie Mac conventional loan. And there are loan lookup websites in this chart that's linked here to help you find out which set of policies would apply to your client's loan, as well as all of these other kinds of loans. So I would suggest keeping the chart handy. So now we're going to talk about what loss mitigation has looked like prior to COVID. So 10 years ago or so, when the mortgage market melted down, I guess it's more than a decade now, there was a new program that was created called the Home Affordable Modification Program. Until then, when someone had to pay back the loan amounts that they owed because they hadn't paid for a while, they often had to do a repayment plan where their payments increased. So starting with the HAMP program, it was institutionalized across the market that people could get a payment reduction. And this is how the payment reduction worked. First, they would capitalize all the arrearages, the amounts that were due and unpaid. Then they would reduce the interest rate. Then they would extend the term to up to 40 years. And then they would potentially forbear some principal. And the goal here was to get to a target payment of 31% of the gross income of the homeowner, which meant collecting information about the homeowner's income in order to determine whether 31% had been reached. And so you didn't necessarily do all of these steps. You did as many as you needed to get to that 31%. And the current FHA HAMP program has retained a lot of these features. Next slide, please. Now, if you have a Fannie Mae or a Freddie Mac loan, the rules are slightly different. They moved away from this income targeted payment reduction and went instead to what's called the Flex Mod, which we'll talk a little bit more about. And the Flex Mod is the main loan modification. It's not based on an individual's income. And it's really the only option other than making payments that are greater than your regular payment to repay the missed payments, or disposing of the property through a short sale or a deed in lieu. There's also something else which we'll talk about more, which is in the second little bullet here called the payment deferral, which is a post-COVID approach of just resuming your payments and putting the rest in a balloon at the end. Next slide, please. So the Gse Flex Modification is this new structure in which the terms are uniform for everyone. There are fixed reductions of the interest rate and the extension of the payment term, and they're not trying to get to an individualized payment for each person, but rather a generic payment reduction of around 20%. It's not income-based unless you get to the very last step where there can be an additional adjustment, but it's only available for people who are fewer than 90 days delinquent, which is often not the case. Next slide, please. So this is how the Flex Modification works. It's pretty similar to that HAMP modification we just looked at, except that it's not going for that 31% of income payment reduction. You capitalize the arrears, you set the interest rate, usually at the Freddie Mac rate, you extend the term to 40 years, and then you can forbear principal. Now, there are two ways to get a Flex Modification. This is pre-COVID. It's still true now. It used to be that you had to always apply and you had to document your income here because income isn't as relevant. a borrower can request it, but also the servicer is obligated to determine if the borrower is eligible by running those numbers and then proactively offering that to the borrower. Next slide, please. So VA traditionally has had a lot of different options, and Lynn is going to go through this slide and then go into the next section for us.
Yes, thank you, Elise. For the traditional VA options, there were always the repayment plan, special forbearance, the modification, the affordable modification, which is runs very similarly to the one that Elise just described, a short sale or deed in lieu, always a refinance or assumption. And in certain instances, the VA can take over the loan. And we have some resources, people to contact within the VA in case you're having a servicer who is giving you problems in following the traditional as well as the new VA options. I did want to mention, though, that there's a case in Florida that has been very helpful in our GSE cases, or particularly our VA and HUD mortgage foreclosures. There are certain responsibilities that the servicer has before, if a veteran is delinquent in their payments, to communicate with the debtor and see, or the borrower, and see what options might be available, including all of those options, that the traditional ones we just mentioned, as well as the new COVID ones. And so we were having trouble in courts in Florida, with the courts recognizing that these requirements that are either found in regulations, mortgagee letters, or other locations, and sometimes they're statutory, of the pre-foreclosure workout attempts were not part of the actual mortgage itself. And so judges were saying, well, it's not part of the mortgage, so we're not going to recognize that as a valid defense. But the DeLong case that's referenced in the materials, as well as some other cases that we'll see later, have the courts recognizing this pre-foreclosure requirement for the VA as well as HUD prior to filing a foreclosure. But since Florida is a judicial foreclosure state, it makes it very helpful for Florida borrowers to be able to get this into the foreclosure process. This is we have several charts here, and I'm just going to go through those very quickly. You'll have the slides in your materials. So I don't want to comment too much on the slides. These are the information is valid through towards the end of last year. I thought it was interesting to note the number of the percentage of performing loans, which was actually high to me. And also, similarly with this slide, you'll see that there were 8.2 million homes who were in forbearance, which was very encouraging to see that borrowers were taking advantage of that, and 79% were now performing. Again, these numbers are surprisingly high to me, so I was glad to see it. Here is the breakdown of loans in forbearance, and you have your FHA, VA, your government-sponsored entity loans, your private mortgage, backed security loans, and portfolio loans, just to give you an idea of the breakdown in forbearance that were allowed. And I thought it was interesting that the private label mortgage-backed securities had such a high percentage, which I think is a good thing. So these were the projected forbearance exits. In other words, people anticipating getting out of forbearance toward the end of the year. Last year, broken down into the types of loans as well. And this is a subset of the loans. We'll be talking a little bit more about reverse mortgages later, but this gives you an idea of the number of reverse mortgages that were borrowers were taking advantage of the COVID extensions. And I guess conversely, through the other slides, I was starting to see that there weren't more borrowers who had requested the forbearance. And I think part of that may have been because borrowers either didn't have access to the information because some of my 80 and 90-year-old borrowers are not very internet savvy. And perhaps they just didn't know that reverse mortgages were included in the forbearance opportunities. Okay, so these are some materials you might find helpful. The National Consumer Law Center, where Alys works, is just always the source of information about what is going on by the minute with pre-forbearance, pre-moratorium, pre-COVID, post-moratorium, post-forbearance, post-COVID. During all of that, they are the resource for everything. And so I've COVID related and mortgage related, and these rules and guidelines, they seem to me anyway to change frequently. And there has been some news about new programs and just information about learning how old programs are working. So the National Consumer Law Center site, and the second one underneath that is for the National Association of Consumer Advocates, which is also a wonderful organization that provides a lot of information about pre, post, and during COVID opportunities for borrowers. So Elise mentioned earlier, we'd be talking about who the underlying entities were, and then we'll talk about the servicers as well. But just to give you an idea of what types of mortgages that we're primarily focusing on, you've got your Fannie Mae and your Freddie Mac mortgages, which are often considered as part of the government-sponsored entity mortgages. You've got HUD, which is the FHA mortgage program. The VA is obviously the VA mortgage program. The USDA is the home loan program. We haven't seen a lot of these. I think we see them primarily in rural locations of Florida, but these are the entities other than the ones that are private label or that don't have any relationship to these types of loans. But these are the key phrases of types of loans or types of government sponsored entities or other guarantors that might be involved in the servicing process, or not servicing, but in the decisional process. And as Elise mentioned earlier, it's not real clear when you're looking at the documents if a loan's Fannie loan or Freddie loan. A lot of the loans in Florida you'll see they use either Fannie or Freddie forms, but they're not necessarily Fannie or Freddie mortgages. So you can go to these websites and plug in the address and other information and determine whether or not your borrower's loan is a Fannie or Freddie. And then if it's still held by Fannie or Freddie, there may be concerns with assumptions. The Federal Truth in Lending Act provides a way, this particular statute provides a way that a borrower or their representative can reach out to the servicer to find out who owns the loan. Using the website's a lot quicker, but certainly if you want to make it official, then you can send the Federal Truth in Lending letter. Technically speaking, there's statutory provisions for violations, for damages, but they're really difficult cases to bring because in Florida, you have to get around the fact that you're dealing with a servicer or subsequent owner as opposed to the originator. And then I can't say enough about how helpful Regulation X and RESPA have been in all of our informational efforts, as well as notifying a servicer we believe an error has occurred. But anyway, these references you can use to help find what type of loan that you're dealing with. And one other thing about the FHA insured loans, because those loans do come with the protections that I mentioned earlier when talking about DeLong. Sometimes FHA loans are no longer FHA loans. HUD sold many of their delinquent HUD loans through the Distressed Asset Stabilization Program. And so you need to call the HUD National Servicing Center in order to make sure that an FHA loan is still an FHA loan. And I think will find that they're helpful in other ways as well.
And can I just jump in a second? I want to tell people that Fannie and Freddie have also sold a lot of loans. And so if something was a GSE loan, it may or may not continue to be a GSE loan. And then it won't show up in the lookup anymore.
Thank you. That's really helpful. Okay, so here there have been, as I mentioned earlier, a lot of, when I say changes, I don't mean necessarily going backwards, but just new programs are being added and clarifications are being provided. So these are the links that you'll find in your materials, as well as the link to the NACA program or NACA information, or I'm sorry, CFPB information relating to what options are available. And I check those quite frequently just because it's important to stay on top of these things. And so if you're trying to determine what type of loan, the last statutory reference that I mentioned, which is from RESPA, that's the statutory reference you can use to send what's called a qualified written request, which has been a part of RESPA for a really long time, but didn't have the teeth that it does now, or a request for information where you can find out the owner, any other information relating to servicing of the loan. The response is supposed to be within 10 business days of receipt. And then you can find some samples of how to put together a qualified written request and a request for information. One thing I might mention is that it's really important that when that letter is sent, that it's sent to the proper address. Each servicer has a designated they should have, and which a qualified written request, notice of error, request for information address that has to be used to qualify for a proper qualified written request or notice of error that they have to respond to. So you want to make sure that you go online to find out the correct address to use. And it should also be included in monthly communications from the servicer relating to the status of the account.
So now we're going to talk about some specific COVID-related options in more detail. First, we'll focus on FHA and Fannie and Freddie. So for all of the loans that are government-backed, whether it be FHA, VA, and USDA, or the conventional loans from Fannie Mae and Freddie Mac, the CARES Act in March of 2020 established a foreclosure moratorium and the availability for forbearance. And even after, some time passed, those agencies all extended those protections. So the foreclosure moratoria were in place until the middle of last summer. And then at the same time, those agencies were also establishing rules for borrowers to get forbearance, a time during which the borrower didn't have to make a payment, although those amounts would obviously be due later. So for FHA, they created a bunch of very complex rules about when you applied and what your circumstances were and how much forbearance you could get up to 12 months. And so there's a mortgagee letter cited here, and there's a chart in the mortgagee letter that describes various circumstances and timelines and how much forbearance someone was eligible for. So you always want to make sure that people got what they were eligible for and they weren't wrongfully denied. Fannie and Freddie have a more straightforward rule that you could get up to 18 months as long as you apply by a certain date. Now, FHA has developed, as Lynn was noting, many new options, and I want to highlight a few of those here. This slide has a lot of information, and it's not meant for you to digest it all now. It's for you to take back with you and use as a resource. So the first thing is that the blue link at the top will take you to the FHA Policy Handbook 4000.1, and that will give you the details on a lot of the policies. And then the other thing to do is to look for the mortgagee letters, because that's where a lot of the new policies are. So I want to highlight the last three for you. 2021-15 established something called the Advanced Loan Modification, or the ALM. That's something where a homeowner can be offered even before they do anything, a loan modification that they can just accept without providing any more information. It would provide a 25% payment reduction, but that involves being able to do those steps that we were talking about before, extending the term, lowering the interest rate, without needing to put any money at the end of the loan. If you need to put money at the end of the loan, then you're back in the regular COVID options from FHA. And that's Mortgagee Letter 2021-18, which came out last summer and clarifies how the waterfall of options works. And the main option, as I said before, FHA has a loan modification usually called FHA HAMP. But for COVID affected borrowers, they have something called the recovery modification. And it doesn't involve an application or any income information. Instead, it's a 30-year modification based on the same type of waterfall and payment relief. And you can also get a partial claim, meaning you can take money that hasn't been paid and put it at the end of the loan as a balloon. And there's a maximum in terms of how much partial claim someone can get. And so if they've maxed that out, then that won't be available to them. And then the last thing is that FHA established this 40-year modification option where you have to use the partial claim because they don't want people extending their term past 30 years unless they've also exercised the balloon option. And HUD also clarified here, and this is important for people, that while they're going for 25% payment reduction, people are eligible for more than that. So if your client needs more than that, this mortgagee letter makes clear that you can get that. So the CFPB put out a variety of guidance, and there was one piece in particular that was very useful, which is that they normally have a rule that a homeowner has to submit a complete written application in order to be reviewed for loss mitigation options. And that's so that they can be reviewed for everything and that the servicer won't be selective. But because of the volume of COVID and the urgency of everything, they've created an exception to this rule for streamlined modifications. And that allows these various modifications that we're all talking about today to be offered to the homeowner without a written application. These are the terms under which those modifications, have to be met. So for example, it can't be more than 40 years, the payment can't increase. But as long as the loan meets that, and all the government loan programs do for modifications, then you can do it without a written application. Of course, if someone can't qualify for any of these, they can still apply for another option if it's available, like for FHA borrowers, FHA HAMP. Okay, so now we're going to talk about the GSEs. We're not really going to talk about the slide. These are just some resources for you to know where some of the bulletins. Fannie Mae uses lender letters and Freddie Mac uses bulletins. But in the next slide, you'll see what their newest approach is. FHA has something similar called the standalone partial claim. Fannie and Freddie call it the payment deferral. These are options for people who can resume their payments, but can't make a payment higher than their regular payment. If they can do a repayment plan. But if they can only resume their regular payment, then you take that balloon, like we were talking before it with the partial claim, and put it at the end. And this is the set of letters that Fannie and Freddie put out describing that option for people. So just want to flag a few concepts that are important here. We've got the option we were just talking about where someone can resume their payment and then they put the rest, the amount that they missed at the end in a partial claim if it's an FHA or a VA loan, or a deferral if it's a GSE loan. Next, they might be able to get a loan modification where they where they reduce their payment, but they would also be putting some amount at the end. Generally, COVID options are targeted payment reductions. They're not based on income, and they're part of a streamlined process. So the next slide just shows you the waterfall for GSE loans. You've got the payment deferral if you can resume your payment, and then the flex mod if you need a reduction, and then disposition options. I'm going to turn it over to Lynn now.
Okay, we're going to talk a little bit about reverse mortgages and the COVID policies and protections. And so just generally speaking, again, for your information, these are the statutory references, HUD regulations that we use quite frequently in reverse mortgage litigation. The updates are generally found in mortgagee letters. There's also an HECM handbook, and there's also on HUD a really nice resource for questions and answers. So I'm pretty sure everybody is familiar with reverse mortgages by now, but just generally speaking, it's a type of mortgage that you can get if you are over 62 years of age, and you don't have to make any monthly payments. There are charges that are built in to the origination, and then there are fees that are charged throughout the life of the loan for different purposes. Some of them legal and some of them not so much. So it's always important to make sure that you know what types of charges are being assessed. So if you don't have to make payments, how in the world do you default on a reverse mortgage? Well, the one way is to have the last surviving borrower die. And I'll go through these real quickly and come back to that one. Or the last surviving borrower sells the home or transfers title in some way, unless they retain a life estate, which means they're conveying title to their home away, but they're keeping within that document the right to stay in the home until they pass away. If a borrower moves and that the property that is secured by the mortgage is no longer their principal residence, or they're away from the home for up to 12 consecutive months if the absence is due to medical reasons, or, and this is the one we see, I think, a lot, particularly recently in Florida, is that the borrower fails to pay property charges or maintain the property in what's considered a saleable condition. Now, property charges can be homeowners insurance, and it is taxes, ad valorem taxes, it's HOA dues, it's COA dues, any of those sorts of things. And so I wanted to mention the last surviving borrower dying as a point, because oftentimes we see in Florida, we see a borrower who is, say, in their 60s, mid 60s to late 60s, who has a spouse that is under the age of 62. And so in order to make that mortgage happen, oftentimes we see something that I might describe as kindly as shenanigans, where they will have the owner transfer title and out of the spouse's name and etc. Spouse, or they have the spouse sign the mortgage, but not the note. And unfortunately, well, we had some really great cases out of legal services of Greater Miami that found that the courts did some incredible things with the rights of survivors and HECM mortgages. Unfortunately, that was all undone. And so if we're now getting court decisions where if the older of the couple who signed the note and the mortgage passes away, and you have the surviving spouse who happened to be younger, who did not sign the note, but only signed the mortgage, courts are finding that that person is not a borrower for purposes of being able to stay in the home. And so that's why there's another HECM program that we'll talk about. But we do see a lot of situations where a person who was a spouse signed the mortgage, didn't sign the note, and they're not considered a borrower, which is very unfortunate. We've seen a lot of abuses in foreclosures in Florida, and just to give you a couple of stories, I don't want to get us bogged down in this, but what we see quite frequently is elderly people who are living in their homes who are being sued in foreclosure for not occupying their homes. Ironically, in these mortgage foreclosure cases, when the borrower is served, they are served at their home, which means that is either their their legal residence, and oftentimes homestead. So it means they live there, or service is bad. So either one, the lawsuit is wrong because they just served the borrower at the home where they live, or and the lawsuit should just be dismissed altogether. But unfortunately, those cases, even when the borrower is served at their home, meaning that's where they live, the mortgage foreclosure will go forward. And if the elderly person doesn't get help in that, then they're going to lose their home through a foreclosure unless a judge intervenes, and without someone else bringing it up and saying, look, how could they not be living there if they accepted service there? The other problem with that is that there is this form that the servicers will send out each year. It's an annual certification where the borrower is supposed to indicate on this certification that they still occupy the property and return it to the servicer. The problem with these letters is that there's no advance warning to the borrower that they're going to have to send these letters. They're going to fill out these letters and send them back every year. It's not something they're going to find in the mortgage. You can interpret it from the regulations, but I think there are good arguments that it's not required. But at any rate, what happens is elderly, and I've seen this over and over again, but elderly borrowers will oftentimes have their adult children helping them handle their affairs. And so I've had several adult elderly borrowers who were victims of identity theft and all sorts of scams and siding, no telling. So their kids tell them, don't open any mail that you don't know who it came from. Don't answer the phone if you don't know who's calling. Don't go to the door if you don't know who's on the other side. And those are the three ways that servicers check to make sure if someone is still living there. So the great advice that the adult children are giving their parents are going to get them foreclosed upon. But what else do the elderly parents do? Excessive property charges. A lot of borrowers we're seeing coming back who got Elmore funds to reinstate the mortgage. And we see that when we dig into how the money was utilized, we see that servicers were taking the Elmore money and using it to pay themselves attorney's fees rather than buying the insurance they were supposed to purchase in the following year, or rather than applying all of the Elmore funds to the delinquency. The last thing I'll say about that is, I guess my most sensational foreclosure that I did, because at the time it involved Steve Mnuchin's name got drug into it and it got to be a whole political thing. But the HUD approved a foreclosure because HUD has to approve the reverse mortgage foreclosures. HUD approved the foreclosure because the elderly person who had previously been sued for not living in her home, even though she did, they turned around and sued her for not paying because she owed them 27 cents. And I don't know how many hearings I went to where I would say to the judge at the outset, look, this mortgage foreclosure is over a 95-year-old woman's home who they say owe her 27 cents. And the judge would then look at the other side and say, with an incredulous look, and say, this can't be possible. And the plaintiff or the servicer's attorney had to look at the judge and say, of course they did, that she was delinquent. And very quickly, what happened was they wrote her, she owed them like $1,400. So she wrote him a check, but the check was 30 cents short. So they sent her a letter that said, you owe us 0.3 period. And she read that as 3 cents. So she wrote him another check for 3 cents. And so she still owed him 27 cents. And then she ends up in foreclosure. So last thing, and this is just me editorializing perhaps, and I apologize for doing so, but we all have been reading about I'm trying to think of an adjective, but the insurance crisis that we're having in Florida. I know that my insurance premiums increased sixfold this year. And I would say 90% of my elderly clients who have reverse mortgages are being told they can't get insurance because they need a new roof or several other reasons. So we're having a special session convened by the governor to deal with the insurance issue. And of course, it's attorneys that the insurance problems are being blamed upon, and not the insurance companies. But I'm just curious how this is all going to play out if it's a type of default to not have insurance and you can't get insurance, because it's also difficult with materials to get a new roof right away. So anyway, that's not a very positive note to end up with that slide, but I do have concerns, and hopefully we'll see something good come out of this session. So loss mitigation options for reverse mortgages. One might think, well, that you don't really need loss mitigation if there's no monthly payment obligation, but this involves primarily your repayment plans if the servicer has to purchase force-placed insurance on behalf of the borrower, which ironically now force-placed insurance is sometimes cheaper and provides just as many benefits as the insurance that we can all get in the private market, even with the insurer of the last resort. So the repayment plan can't include HOA dues, and it can be as long as 60 months, which ironically, I guess, is the length of the longest type of bankruptcy a borrower could also file to try to pay back the insurance or tax expenditures that were made by the servicer if the servicer has to pay ad valorem taxes. And just one more thing about that I wanted to mention, because we always get folks coming in saying, well, we were going to pay our taxes, but we went in to pay the taxes and the servicer already paid. And generally speaking, that happens when a borrower has failed to comply with the insurance requirements. So they're technically in default for not keeping the property insured and paying the insurance. So the servicer will go ahead and pay the taxes, which can sometimes be problematic. So the only other thing I wanted to mention is that the at-risk extension, and I've been using this quite effectively for my borrowers who are over 80 years of age. You just have to show that they have medical disability, terminal illness, extreme medical bills or other types of bills in order to get up to a year pause. And so that means that foreclosure has to go on hold, should be dismissed, but it usually goes on hold. And the borrower, once they reach the end of that forbearance period where they don't have to repay the property charges, then they can ask for another extension. And so your 80 plus year olds can just kick the can down the road quite effectively.
Just interrupting to let you know we have about 30 minutes left. It's 2:59.
Okay, so very quickly, these are the mortgagee letters that relate to arrearages. You can find these letters online. And I'm not going to go through each one of these. I've already mentioned the bankruptcy and these other options, but we will get to the Homeowners Assistance Fund in a few moments and go into that in great detail. And then, so there were opportunities for the delay of the foreclosure. And so many folks took advantage of that. These are primarily the options that were available during COVID. And so we can go through those at a later time. I did want to mention the FHA issued the temporary waivers of the deferral of due and payable status for NBS impacted by the COVID national emergency. So I wanted to point out NBS, that's a big one. That's the non-borrowing spouse. So this goes back to what I was saying earlier, that a spouse who signed the mortgage but didn't sign the note is not going to be considered a borrower. So at one of probably the worst times of their lives, when they lose their mate, they're now also going to be told they're going to lose their home. And there's an MOE option that's available for non-borrowing spouses to try to basically, I guess, assume the loan effectively. But they have a very short window of time within which to do so. So the HUD came out with some policies to extend that deadline, because keeping in mind you're sending letters to a borrower who is no longer with us. So you just know, you don't know who's going to get the letter and how it's going to be received. And so this is another reference to the mortgagee optional election, and it's a mortgagee optional election, meaning the lender. So they get to decide which surviving spouses get to stay and which do not.
Okay, I'm going to go through these slides quickly so we can spend a bunch of time on the Homeowner Assistance Fund. Just quickly, the next slide is on VA. It just reflects that the VA COVID options are very similar. So we're going to go to the next slide. The VA options are very similar to the FHA options. There's a repayment plan if you can pay back your arrearage in addition to your regular payment. There's a partial claim option, which is like the deferral, where you put the past due amount at the end and you resume your regular payments. And then there's the modification with a target payment that can be combined with a partial claim. USDA also has similar options with a targeted % of payment reduction. The next slide is very important because this slide, like the chart I was talking about at the beginning, is information you should keep handy. If you know the rules and your client isn't getting what they're supposed to get from the servicer, this is how to escalate with the various government-backed loan agencies. And now if you have a pen or a pencil or an iPhone or anything else, I want to give you the email address of the person who runs the FHA National Servicing Center. If you go to the National Servicing Center and you make your call and they're still not giving you what you need, you should write an email to Matt Martin, and his email address, which NCLC gives out in all of our trainings, and he's never complained, is Matt, M-A-T-T, dot, the letter B as in boy, dot, Martin, M-A-R-T-I-N, at HUD.gov. He runs the National Servicing Center. He knows all the rules, but that assumes that you already exhausted. Thank you for putting it in the chat, Alexis. That assumes you already exhausted your other options with the National Servicing Center. And these are all the other agencies. We established a special email address with Fannie Mae, and there are details there. If you need the designated third-party authorization form, you can email me and I'll send it to you, or I'll make sure that Lynn and others have it if they don't already. So let's go to the next slide. We just want to remind people that if you have a private loan, it's either held in portfolio by the lender or it was sold on Wall Street. None of these rules we've just discussed apply, but a lot of the servicers are doing similar approaches, which is why Lynn pointed out a lot of those people did get forbearances, and you can use your RESPA, request for information, to find out what those guidelines are. So moving ahead to the Homeowner Assistance Fund, I'm going to just quickly go through what the federal rules generally are, and Lynn's going to talk about what happened with the Florida program. It's basically a $10 billion program that's meant to prevent not only foreclosure, but also to deal with other types of expenses like utility expenses, for example. And the other thing I would point out about it is that there is targeting in the program to low and moderate income homeowners, and there's a broad range of qualified expenses. This is what's in the official statute, and Lynn can give you more details about what's true in Florida. So then Treasury put out guidance that was in July of last year and then updated in November. And a couple of key things here. One is that they said that the funds can be used for an arrearage even if it started prior to January 21st, 2020, which was the date in the statute. So the way the language is in the statute makes clear that as long as the hardship was continuing, the arrearage from before can be covered under Treasury's guidance. They're also encouraging waivers for documentation when documentation is unavailable because of COVID, and they're discouraging exclusions for people in bankruptcy or other things. So lastly, I just want to point out that reverse mortgages and other types of mortgages are encouraged to be included by Treasury, and that there are particular income guidelines. I'm going to turn it over to Lynn, and I'll be back for a little cameo later.
Thank you. So these are some some resources that I'm not going to go through, but these are areas that you can click. There's a guide for homeowners, and then there's another guide for advocates as well as homeowners. These are through the Department of Economic Opportunity, and you should find them helpful on the basics. So, and servicer participation is not required for the servicer to accept funds, but it really makes it more complicated if they don't. There have been, Florida has submitted a plan to Treasury. It's been approved. It appears that at first we were concerned in looking at the material, at the plan, because the plan is not a model in clarity or specifics. I'm not saying it should be, because it was developed for the entire country and each state has to do their own thing. But at any rate, there are more questions than answers right now. And part of the reason is, and I'm again not saying it's a good or bad thing, but we're just now getting the notices of preliminary approval and on homeowners assistance fund funds applications that we submitted over a month ago. So, and we understand there have been over 1 million people who have applied. So the process is moving very slowly. But if the servicers aren't involved, so at first we were concerned it was going to be just the servicers and they were going to be in charge of reaching out to the borrowers and letting them know about the HAF funds, but that was not in the final plan. Now we're concerned that the servicers may not be involved at all, which may be problematic for the foreclosure pause that Elise will talk about, because the servicers have to have real-time information that a borrower is at least being preliminarily considered for the program. And so this is a chart. I'm not going to go through the common data file sequence flow chart with you, but you can look and see how the process is supposed to work before funding, the application acceptance process, when the servicers get involved, when the servicers are notified, as well as when the other thing about this that I didn't see, and so I wanted to get to this, was that it can be used, the uses of the program, as Elise mentioned, are broad. You can even use it for internet, I think, in Florida. And at the beginning, we were a bit concerned as to whether or not, going back to reverse mortgages, if reverse mortgages were going to be considered as a type of loan that HAF funds could be utilized for. We learned absolutely they can, because this property tax and insurance default issue is a big issue in Florida. And so in theory, the lender or the servicer is supposed to be notified that the borrower is being evaluated for loss mitigation and has qualified for the HAF money, and the HAF money has to be used for the requirements, which is interesting, because before, the problem with Elmore was that the money was being used for attorney fees and other things. So we're really just waiting to see how this all plays out, and if the servicers are going to be notified when a borrower is preliminarily approved, for what Elise will be talking about, and a little bit more. So veteran borrowers can use Homeowners Assistance Fund for VA retention options, and you can get more information at that link. And so it can be used in adding to existing waterfalls, partial reinstatements, the CBS streamlined rule, or any other pauses where sums are due, the MHA funds can be utilized.
So one of the questions that's come up during COVID is, when can foreclosures go forward? So first we had the foreclosure moratorium for government-backed loans, and a lot of private loans observed that same foreclosure moratorium, which we talked about earlier. Next, we had these so-called procedural safeguards from the CFPB that expired at the end of 2021. They were around for a few months, right as the moratoria were ending. And they said that a servicer couldn't start a foreclosure, make the first notice or filing unless one of the three safeguards were satisfied. Either the borrower was unresponsive after a certain number of prescriptive forms of outreach, the property was known to be vacant and verified as such, or that the person submitted a complete application and was rejected and didn't qualify for anything. So in general, foreclosures weren't moving in 2021. And then 2022 came and foreclosure started to pick up. But homeowner assistance fund programs were also rolling out then. And so the next slide shows you what we ended up getting after a lot of advocacy, which is that the Federal Housing Finance Agency, which regulates Fannie and Freddie, announced along with Fannie and Freddie, and this announcement came on April 6th, a requirement, not an option, but a requirement. And this is why it matters what kind of loan your client has. If you have a GSE loan, the servicer is required to suspend foreclosure activities for up to 60 days, meaning unless the person gets approved for half funds and they don't need the stop anymore. So you get 60 days of a stop, and it can be extended longer with discretion from the servicer. If the person has applied, meaning if the servicer has been notified that the borrower applied, and then the HAF program from Florida has notified the servicer about that application, which relates to that flow chart that Lynn was showing you, then the servicer is not allowed to proceed with foreclosure activities. So that's something to keep track of. If you see violations of that policy, please let me know. And Alexis is going to share my email address. And the details about the Fannie and the Freddie guidance, which are drafted differently but mean the same thing, are all there on the slide. So then we went, to the rest of the government and said, well, we had asked you to do the same thing as well. What can you give us? And we didn't get exactly the same thing. We got something else. And so a month later on May 6th, which I think is a coincidence, the Treasury Department and then the government-backed loan agencies that do government insured loans, FHA, VA, and USDA, announced that they strongly urge servicers to do the same thing, to pause all foreclosure activity when they've been notified by the HAF program of a pending HAF application. So we didn't get a requirement, but what we did get was a very strong statement from the whole government, supported by the White House, that this is the policy that they want to see. It's a long story why we ended up with that, but the short version is you should treat it like a requirement. And if you have a client who has one of these loans who doesn't get a foreclosure pause when they have submitted a HAF application, then you should let me know and we'll bring it to the White House and we'll get the policy changed if we can. And we'll certainly try to have the agency intervene on your client's behalf. So again, at the bottom, you can see the press release saying that it's an administration policy for all of these agencies, and then links to each of the policies for each of the agencies. I want to point out that FHA makes it hard to find the policy. So you have to go onto this FAQ page and then do a search for HAF. Thank you, Lynn.
Okay, so in the defenses to foreclosure relating to the pause, again, we're not certain that the servicer is going to be automatically linked in the communications between the borrower and the DEO or the HAF program administrator. And so given Florida's court's reluctance to look at anything outside the four corners of the note and the mortgage in determining whether or not there are defaults, we're concerned that servicers, we would prefer that servicers get immediate information from the DEO that when a borrower's preliminary application has been preliminarily approved, so the servicer will know that the case should be on pause. And I say should very loosely because in Florida, strongly suggest the federal government strongly suggesting that servicers do anything to put a pause in the foreclosure is sort of like is just wind passing through the air. And so I've had very recently courts tell me that if loss mitigation wasn't done, that wasn't their problem and they were going to set it for trial. And I assume that that same thing is going to happen since we're only getting which what we got was incredible because we had nothing, and just trying to move that ocean liner to go in a different direction and give the borrower some rights and recognize that a half pause should be implemented. That was huge. It's just making it work in Florida that might be problematic. It's my understanding from the chart that the servicer will get an I notice, meaning they will get the fact that the borrower has applied. And I believe the initial approval, and once a person gets a borrower gets initial approval, they have to set up an account within the DEO and provide all sorts of documents, which is sometimes proving difficult, but we're working with them. So again, we go back to the DeLong case that I mentioned earlier, where you have the federal government saying, we strongly suggest you do this pause, and hoping a court will buy into that based upon what the court did in DeLong, or what the Florida court did in Laws v. Wells Fargo, and that was with respect to an FHA loan. So we have concerns about getting the pause, and I guess that is coupled with the fact that right now, if I have a client who is facing a trial or foreclosure, end of a foreclosure within 30 days, we tell them to apply for half, but we have no hope that they will be approved and receive funds within that period of time. And I don't mean to be negative about it. It just seems like that's gonna, we're just not seeing it play out to where people actual cash is coming through. And again, I'm not trying to be sour about it, because it's an incredible program. It's a lot of money, and it's going to save a lot of homeowners their home, but there are going to be a lot of people who fall through the cracks. And so you can go to the Florida website and get information, because that it does say very clearly who is eligible, types of loans. HECM loans or reverse mortgages are eligible, which was really important to us. Funding caps of $50,000, basically. There is a special category for socially disadvantaged people, as Elise mentioned earlier. I don't know what we're going to do in instances where title is not clear or insurance can't be obtained, at least within within a reasonable amount of time, and we're wondering how that is all going to play out. I wish I could tell you how it's all going to play out, but I haven't seen anybody be formally accepted, being given the HAP funds yet. As to whether or not Florida has an appeal, no clue. I looked at the FAQs on the DEO website. I looked at the plan, and I didn't see anything in particular that would be helpful relating to what Florida provides as far as an appeal. These are and I'm not going to go through all of these at all, but these are just the benchmarks Florida is trying to reach with assisting at least 10,000 homeowners, et cetera, which, sounds like doesn't sound like a whole ton, but it's good for those 10,000 homeowners. Very quickly, for the last two slides, bankruptcy still is an option. And this is basically talking about property charge issues, taxes, insurance. And even interestingly enough, we've had heirs who were living in a property that they received through probate, and they filed a bankruptcy case because there was a taxes and insurance delinquency. And even though they weren't the borrower, they were the owner through inheritance. The bankruptcy, they were allowed to process through the bankruptcy court to get a repayment plan, and the Harmon case is a good example of that. The mortgage modification mediation program, I haven't heard much of that being used as much lately. It was available in all three of the federal court districts, but it's certainly something to consider if still available in your area. So I think now we have time, 10 minutes for questions in case there are some things that people would like clarified or additional questions.
Yeah, right on time, Lynn. I was about to butt in and say 10 more minutes. I didn't see any questions that came in through the chat. I'll double check again, and I'm going to check the Q&A as well.
I mean, I've been checking. One thing I'd be interested in is, first of all, if anybody has actual questions about what we said, but also What are you seeing? What are the problems
Mhm.
that your clients and people in your community are having? What do you want
Mhm.
us to know about what's going on so we can make
Yeah.
things better for your clients?
Yeah.
So anything, what brought you here today? What worries you? Because this is our opportunity to do something about that. If if you're seeing it with reverse mortgages or HECMs or private loans, sorry, or FHA forward mortgages or VA loans or private loans, whatever it is, we want to know what you're seeing so we can help you. We
So
know you're out there
drop
because
it
we
in
have
the
a
chat.
number of participants, drop it in the chat or the Q&A, whatever Alexis tells you.
Yeah, and while I'll buy some time while folks are doing that, with all of the materials that Lynn and Elise have are already uploaded onto the virtual platform. If you scroll down below the video that you're watching, there should be a blue banner that says files, and there you will be able to access a copy of the PowerPoint presentation. Additionally, I put both Elise and Lynn's contact information into the chat. Thank you both for being willing to talk to folks, after the fact and be a resource, because we all know it takes a village, and it's really great to have folks to bounce things off of, especially experts like you.
And
No
we're
takers on the chat. No takers.
Well, we're particularly interested in learning, since this half program is so new. Mandy Mills from Legal Services of Greater Miami and I have been communicating quite a bit, and others, just to see what anecdotally people are experiencing through their clients with the Homeownership Assistance Fund, Homeowners Assistance Fund program. And so anybody's welcome to reach out, because we do get tidbits about the difficulty in creating a new account on the DEO website, and information about documents submitted, and timelines are also a big concern. So if you have any of that type of information you'd like to share at a later date, we really appreciate knowing how the HAP program is working.
Just today, I got an email from folks from a couple of other states about how long it takes from the time someone applies for their servicer to even find out that they applied, never mind to get an answer. And so if you're seeing that in your cases, we want to know that, because we'd like to try to do something about that. We're going to try to bring that issue to the Treasury folks who we speak to regularly. And the more we know about what's going on, the better we can help you do your job.
Awesome. Really great example of community lawyering, of putting the ears to the ground and really trying to take and address the issues that the community is experiencing. We do have about 7 more minutes, folks. Chat it up.
I just want to make sure everybody knew about these wonderful treatises that the National Consumer Law Center puts out. I think we have.
Yeah.
We have all the COVID options written up in the manual now too. And we have a new section on zombie mortgages that's, being developed. So plenty of good information for people.
We have been seeing a flood, particularly during the moratorium. We were seeing an awful lot of foreclosures. Well, we were seeing a lot of HOA and COA, condo association foreclosures, because they weren't put on hold. So they went to town during the moratorium. During the moratorium. And also we are now seeing a lot, and did see a lot, of second mortgages that had been dormant for 7 to 10 years, which is why we call them zombie mortgages, I guess, among other reasons. But so we're seeing an awful lot of, and there are some creative ways to defend those types of mortgages. And the NCLC folks have put together an incredible amount of resources and materials for that purpose.